Welcome back for the final session of the conference. We're hoping we are getting the final words from our speakers, the decisive final words maybe in this panel, no pressure. But we are going to discuss future prospects of the Parity of Esteem today with our two speakers, Professors Nikos Skoutaris and Colin Harvey. So I will introduce Colin first, even though I'm sure everyone in this room knows Colin, but Colin Harvey is a professor of human rights law in the School of Law, director of the Human Rights Center. He's a fellow of the Senator George J. Mitchell Institute for Global Peace, Security and Justice. He's an associate fellow of the Institute of Irish Studies and a fellow of the Higher Education Academy. He is a commissioner on the Irish Human Rights and Equality Commission and a member of the Scientific Committee of the EU Fundamental Rights Agency. Professor Harvey has served as the head of the law school between 2007 to 2012, and he's a member of Senate and the director of research at QUB. So it definitely feels very superfluous to introduce him. But Colin's going to talk to us today about parity of esteem, constitutional futures, and transformative change, which will be about the public conversation around the Good Friday Agreement and analyzing that. We also have with us Professor Nikos Skoutaris, who is a professor of European constitutional law at the University of East Anglia. His research focuses on the interrelationship between the EU and the right to self-determination. His first monograph explained how the EU legal order has managed a secessionist conflict within its borders, and his second examines how the Union accommodates regions that enjoy legislative and political autonomy. He has acted as an advisor to the European Parliament's GUE/NGL parliamentary group for Brexit-related issues, including the Irish border, and his website focuses on secessions, constitutions, and EU law. And today he's going to talk to us about parity of esteem within the European constitutional landscape. And I think he's going to set out the concept of parity of esteem within the broader European constitutional landscape, and in particular within the context of post-conflict and plurinational constitutional arrangements. So without much ado, I hand over to Nikos now.
Thank you very much, Deviani. Also, thank you very much to the organizers for inviting me to tropical Belfast, and also pairing me with Colin. It seems that every year we will be in a panel paired and discussing our views. Also, let me pay tribute to the organizers for actually making such an interesting conference. I have reached this age of my life that I find most conferences very boring. That was definitely not one of them. It was an incredibly interesting and very thought-provoking conference. Okay, so what I want to do in the 20 minutes that I have is three things. The first thing is I want to problematize, test one of the quotes that was in the call of paper. So according to which the parity of esteem requires the state to do something unusual, to grant equal moral value to both the desire to stay within the state and to leave the state. So what I will try to say is that there are other constitutional arrangements in Europe that they do pretty similar things. They provide for this kind of equal moral value. The second thing that I want to do is I want to provide for an explanation why we have such a constitutional arrangements. And despite what has been said during the last day about the indeterminacy of the parity of esteem, about its constructive ambiguity, I want to provide for a tentative support to the concept. And finally, what I want to do is I want to say something about how it can be used in the discussion about the constitutional future of the region, of the island, and of the archipelago, which is partly what this panel is about. So let me start with the first. So Colm yesterday explained very well the whole issue about the Jacobean visions of constitutionalism, and it's true that from a prism of this Jacobean vision, concepts that have to do with parity of esteem they sit uncomfortably with it. Notwithstanding, I mean, when we speak about post-conflict constitutionalism and peacemaking constitutionalism, we see that these kind of arrangements are not that unusual. I would say, in fact, that if we look at comparatively the Parity of Esteem, there are provisions that are quite similar. Before I go to them, let me preface that by saying that whenever I provide for a comparative analysis of this kind of concepts, either in Northern Ireland or in Cyprus or in Bosnia, there's always this kind of complaint that, yes, but our situation is very different from whatever, right? Now, what I want to say is that, of course, it is true that the political and historical trajectory that has led to all those arrangements is very different in every case, but it's important to see them also comparatively in order to appreciate not just the similarities, but also how different constitutional orders have adopted similar arrangements, not least through this idea of migration of constitutional ideas. So to my mind, there are three kinds of constitutional arrangements that share some similarities with the Parity of Esteem. The first one, we have already mentioned it, has to do with constitutional arrangements that recognize the constituent nature of some peoples. And this is the example of Bosnia and Herzegovina, to which Chris has referred. This example is particularly interesting, not least because of the, how should I put it in a politically correct term, the wildly different visions of the constituent peoples of Bosnia and Herzegovina, but also about how the internal borders were actually designed in this place, right? We had three constituent peoples that had completely different views about their constitutional future, but they are considered, all of them, equal constituent peoples. And then, of course, within the constitution, there is a completely different approach and treatment to other minorities. Another example is, of course, Cyprus, right? What is interesting about Cyprus is that neither of the two ethnic groups had as a vision to create a common state, right? The Greek Cypriots wanted to join the Greek motherland, the Turkish Cypriots to partition and join the Turkish motherland, right? So, and they were put together in the 1960 constitution, which doesn't provide for a term called constituent peoples, but it's drawn up explicitly on the terms of the two communities and then gives some minority rights to three small religious minorities, the Maronites, the Latins, and the Armenians. And this idea of constituent peoples within Cyprus has been actually elevated if one looks at the later peace plans. I mean, one of the agreed parameters for the Cyprus negotiations is this idea of political equality, right? In the 2004 Annan plan, we were talking about two constituent states. And it's interesting to point this out, not least because after the 1960 constitution, now it's the Greek Cypriot community that is very much in favor of keeping the republic, while the Turkish Cypriots, of course, after 1983, they have created their own state, which is unrecognized. Notwithstanding, in 2004, when the UN proposed the reunification plan, they went for a new concept called a virgin birth, so that the new state would be kind of not just a continuation of the Republic of Cyprus, but a virgin birth where both communities are sovereign over this new state. We spoke about Spain, and we said yesterday that although, of course, there is a recognition of the indissoluble unity of the state, in Article 2, there is also recognition of the autonomy of the regions, but more importantly, if we look at the transitional provisions, there is a recognition of the fueros, there is a recognition that the historical communities would have a fast-track approach towards autonomy, but also the open nature of the constitution, right? The fact that the regional statutes, the estatutos, are considered part of the constitutional order. They are organic laws of the same kind of constitutional value. And as I mentioned yesterday, even the Catalan statute, the most recent one, was actually approved by the Cortes, although later on the Constitutional Court struck it down. Another example is Macedonia. after the Ohrid Agreement of 2001. There they made kind of a sleight of hand. They haven't recognized the Albanian ethnic group as constituent peoples, but they have provisions which say that, if in an area more than 20% speak another language other than Macedonian, and of course that would be Albanian, then there is a heightened protection towards this ethnic group. So that's one group. The second kind of group of arrangements has to do with when a constitutional order indirectly recognizes the equal moral value through constitutional arrangements. I mean, Colm spoke about Belgium yesterday in quite some extent, but there are other cases as well. I mean, Bosnia, again, Macedonia, indirectly, again, and there is an informal. Cyprus, the 1960 constitution, Switzerland, and so on and so forth. But the third, and perhaps the most controversial from a Jacobean point of view, is when a constitution provides for the right to secession, right? And indeed, I mean, again, it's not the most common thing in the world. Indeed, most of the constitutions either are silent on secession or they explicitly prohibit secession, but the picture is more nuanced than what is presented often. I mean, I think Mikkel referred to Ethiopia, to the Ethiopian constitution, where there is recognized the right to self-determination to each and every nation and nationality in Ethiopia. There is the constitution of St. Kitts and Nevis that provides for the right to secession of Nevis. My favorite one, Liechtenstein, which provides for the right to secession of each and every commune in Article 4. But I mean, in Europe, apart from Liechtenstein, we have the Danish constitutional order that recognizes the right to secession and independence of Greenland, not unification with the US. I mean, here in the UK, of course, Northern Ireland and Scotland, but okay, despite the decision of the Supreme Court, there is a way for them to become independent. Spain, we discussed yesterday that although there is this principle of the indissoluble unity of the Spanish state, in 2014, the Constitutional Court, when they had to discuss the consultative Catalan referendum, so this is the referendum before the 2017 referendum, it was a consultative referendum, what the Spanish Supreme Court said is that any approach, and I quote that now, that intends to change the grounds of the Spanish constitutional order is acceptable in law as long as it is not prepared through an activity that infringes democratic principles. So what they said to the Catalans is that you may even secede if you follow a constitutional process, which of course is very difficult, but one has to appreciate how different is the approach of the Spanish Constitutional Court from, let's say, their counterparts in Italy. In Italy, the Italian Constitutional Court, I think in a case about Veneto, about the Statuto in Veneto, they said that the indissoluble nature of the Italian state is not something that is amendable, so there cannot be even an amendment to the Italian constitution that allows for that. And the most Jacobean, perhaps, constitution, the French one, in the preamble, recognizes the right to self-determination for overseas territories, and they have done that also very practically. In the case of New Caledonia, there were 3 referendums during the last 10 years. So the picture that I'm trying to present here is that, parity of esteem, at least the different aspects, can be found in many different constitutional arrangements. Now, why is that? Why we have this kind of crack in the Jacobean vision? Well, I think the best answer to that comes from the work of Bell and Christine Bell and the work of Lerner, who both, in different ways, they said that, okay, why do we have this kind of weird and paradoxical arrangements? Because we want to preserve this kind of conflicting claims about the constitutional vision and create this kind of institutions whereby those conflicting visions would continue being negotiated, right, in peaceful means. In a way, it's what I think Leah said in one of her interventions yesterday, that it's better to actually have this kind of discussion peacefully within the constitutional order than outside the realm of law and by killing each other. Equally, Hannah Lerner has discussed how important it is to have this kind of constructive ambiguity when we are doing constitution making in divided societies. Are there problems with this approach? Clearly, and we have actually highlighted some of them during those 2 days. One is what I think Yuan said when he spoke about, kind of freezing the conflict, and he spoke about, let me see here, that they are traitors because they don't respond to the evolving political aspirations, right? And I think this is true, and from a constitutional engineering point of view, it's very, very important to if we want to actually build this kind of arrangements, how we are going to use them and how we are going to entrench them. I mean, personally, I think that elevating them to eternity clauses, something that we haven't discussed so much during those 2 days, is really problematic because it doesn't allow the necessary flexibility. But I think that there is a very, very good argument in favor of entrenchment. And the other, of course, problem is the problem of the others, right? And we have that in all those arrangements. We saw that in the case of Bosnia, in the case law of the Court of Human Rights in Sejdić and Finci. We see that in Cyprus with the problematic dealing of those 3 religious minorities and the fact that there is no space for the recognition of other minorities. We see, we have discussed that during those days with regard to Northern Ireland. And I think here it is very, very important to understand through the case law, both of the European Court of Human Rights and of the European Court of Justice, what are the limits and what are the limits of actually creating this kind of exceptional arrangements. Which leads me to my third and final point, which kind of connects the previous 2. Now, perhaps the most nuanced approach when it comes to secession and the right to secession comes, of course, from the Canadian Supreme Court, where in the Quebec reference, what they said is that, okay, if there is a clear majority, this gives rise to reciprocal obligations to all parties to negotiate secession, and that in those negotiations, all parties have to be led, have to be guided by some constitutional principles, including federalism, democracy, rule of law, protection of minorities, and so on and so forth. Why is that a very important discussion? Because it's perhaps the best depiction of this idea of domestication and proceduralization of the right to secession, something that has been argued by people like Tancredi, Norman, Mancini, and so on and so forth. And in a way, what all those people argue is that by actually creating a clear procedure with clear principles that has to be followed for the secession, something that is considered sometimes, an event that is considered sometimes as a matter of fact, to remember the Batinder Commission quote, it becomes part of the law and has to follow certain legal principles. So to go back to the Parity of Esteem thing, given that it's an obligation that is imposed on the sovereign parliament over Northern Ireland, whether it's the Westminster or the Irish one at a later stage, I think that the Parity of Esteem can play a role in 2 different ways. The first one is in the way that the Canadian court has thought, as a guarantee that this process, this possible process of reunification, no matter what, will follow the Parity of Esteem and will actually respect, the end result will respect the Parity of Esteem of the 2 communities. So it's this idea of domesticating something that can be a very difficult event to deal with, but domesticating and trying to actually provide for a guarantee that it would follow certain rules. And the second one goes back to something that Tom and others said, is that it can provide for and Colin Murray, provide for a discussion in the current debate about the constitutional future on the island, about how the Parity of Esteem will be materialized if there is a reunification. What are the precise modes that will be used? to my mind, and to go back to what I said when we were speaking with Colin, I think that parity of esteem would mean some kind of political recognition that goes beyond just the enshrinement of rights and would have to do with recognizing the particular political nature and political rights of both communities. Thank you very much.
Thank you, Nikos. Now we listen to Colin.
Good afternoon, everyone. Good afternoon. I'm conscious that I'm standing between you and the sunny afternoon out there. Very timely day to be having this. Always carry this everywhere. Obviously, 10th of April. Very important time. 27 years ago, I think. That's my math. Well, yeah. Okay, so really timely event. I want to thank Tom, Katie, and Ureg for the invitation to be here and for organizing the event, and also for, I remember, I think, the initial discussions in Essex a while ago where this all started, so it's good to see this continuing. There's also absolutely nothing left to say at this point, I think. So, what shall I say? The aim of this session is to focus on the future, and that's perhaps what I can most usefully contribute to the discussion today. And the blend of reflections and thoughts based on a merger of law and politics, if you like. I'm going to let you into a big secret this afternoon, a big reveal. I have a view about the future, right? But obviously don't tell anyone that. And I think part of saying that and talking about subject position in these debates, which I think we have to do, even in contested and deeply divided spaces, is how we navigate all that will be an issue for the future of this island too. One of the great strengths of this university, many other universities, but particularly this one, I've never worked in a more socially engaged institution. In other words, for example, many of my colleagues who work in the area of equality and human rights are also very heavily involved in trying to shape the world in and around and beyond the university. In fact, it's just what we do. It's what we've always done, whether that's been involved in NGOs, other civic conversations, public or private. And so there's no reason, really, not to continue in that mode as we reflect on the constitutional future of the island. That's what I've done. That's what I've always done, and that's what I'm going to continue today. So, there you go, that's me. Now, so the first starting point, just to share some reflections, which I suspect were covered yesterday in the discussions. And maybe this is just me, my stage in life, sort of mid-50s, having followed through for the last few years in various public bodies as well, is that the interpretation here of parity of esteem has never, ever really been resolved. It's never really been respected, if you agree on what it means. But primarily the interpretation of it hasn't been agreed. So it has remained an ongoing political, legal contestation in this society right up to this day. It remains fought out. That's because I think people carry around in their heads two different versions of what this all means. You know, and many of us beyond the university will have heard these sorts of strands. There's one school of thought, just to put it a bit crudely, right? People say, you're in the UK, that may change in the future. There's a mechanism for that. We'll do a few tweaks here and there, but that's the position. It may change in the future. And that's a mindset that's widely held, I think, here about what the agreement does, and people will have heard that, versus a much more binational understanding of what parity of esteem means and those connected concepts. that places a very, very strong emphasis on legally protected equal status for the two main traditions. And in that school of thought, and I'm caricaturing, the issue is not that we don't know what parity of esteem means, but that we do know what it means. We just don't like following through on the consequences, law, policy, and practice all over the place, or for many people here, find it unpalatable. And I think those conversations play out every week and day in this society, in statutory bodies, in civil society, and universities. And how it's been interpreted and applied in the past will, I think, impact on next steps. Just a very anecdotal example, there are many people in the constitutional change school of thought who feel it's never really been respected fully in the last 27 years here. Now, that's not an indication of what should happen in the future, but that's certainly a view that's out there. Second thing that's really noticeable about reading the agreement, and I'm sure will have been covered yesterday, is just how much the agreement places an emphasis on subnational discharge of the responsibility. We look at the use of parity of esteem in the agreement. There's a very determined focus on the jurisdiction of Northern Ireland as an entity, in addition to all the other obligations that will exist in the future in international law, EU law, and domestic law. But it's very noticeable that a lot of the focus on the agreement is on discharging the responsibility in something called Northern Ireland. And for those who follow the United Ireland debate will know that there is a school of thought within that conversation that contemplates the entity or jurisdiction coming to an end over time as well. I think it's something we need to discuss. The third thing I want to say about the future is, and I say this with a sense of where I think the conversation is at, both within the university but in the wider society here. I think this region is moving into a phase over the next few years. You may disagree, but I think it's hard to explain what's happening out there in terms of political and civic mobilization, academic research on all sides in this argument, where people are going to start putting their cards on the table about the future, which is why this event really, really, really matters, right? So I think having really taken a conversation into the mainstream of public life on the island of Ireland, I think the next stage in this discussion may well be one where there's much more sharpened focus on what the proposals are going to be if there were to be United Ireland. As you know, people here have a choice, union with Britain, United Ireland. Well, what would the United Ireland bit look like? So maybe share some thoughts on that, if that would be helpful. You can have a conversation. I think ultimately, in any constitutional context, this really boring and tedious answer to that, there's going to be a continuum between continuity United Ireland and transformative United Ireland. And just like a bit like the agreement in Northern Ireland now, the continuity wing, if you like, and the transformative wing will battle it out. And obviously it begs all sorts of questions as to what both of those means, but where are the proposals going to end up in that continuum between something that looks very much like what we have now to something that looks radically different? So what do you want in a united Ireland? What is required of a united Ireland? So for example, you'll hear civil society, a politician will talk about, I'm going to start with a blank piece of paper. And I often think the lawyers in the room often say, hold on a minute. There are like rules and obligations and things like that. So you're not trying to undermine any sense of ambition. You're just going to point out the fact that there are things that are going to be required of the future as well by the rules that are there, international, EU, domestic, and all of that. Similar with people who refer to United Ireland being a new state. You know, I'm a big fan of novelty and new and all that, but it won't be a new state in the sense that we're talking about it legally. There are also questions about what might work and success. So what proposals are going to, thinking about this event and why it's so useful, what will be proposed and should be proposed in a programme for a new Ireland, if you want to call it that are likely to succeed in work. And this is where all the research that's been done at the moment, including the Orange research and deliberative forums and surveys and polling and all of that, and all the academic papers are really useful in working out where people are and what might work. Obviously, you have to define success. What counts as success? Your success mightn't be my success, but of what's likely to make this work. And I detect a real appetite reflected in some of the really, really interesting language of preparing and planning on a fairly widespread desire to get this right, whatever happens next. And the other thing is, I suppose, the question we have to raise today is, what might people be willing to do to achieve parity of esteem? In other words, those who don't want constitutional change and don't want a united Ireland, what and where will they be willing to go in order to achieve some of these values? And the history of the island of Ireland tells us where that can go wrong, including all the way up to armed conflict as well. So questions for discussion, not for solution. Will Northern Ireland persist over time or be phased out is a real question in terms of the unity discussion. Over time, will we move to a much more integrated model? How will the Ulster British tradition be respected if that's the case? Is it essentially done? Thus an argument for continuation of the jurisdiction here via a Northern Ireland-based solution, or within an integrated Ireland, or a combination of both? What are the guarantees, assurances, and protections that the Ulster British tradition in particular are going to need, not just to get along and feel comfortable, secure, and safe in a united Ireland, but will mean that people are willing to make a success of what happens next and play a full and active part? So I think that question of parity of esteem at what level, which has been addressed over the last 2 days, is an intriguing one in terms of how the agreement is framed. I think it presents a very particular challenge to integrative unity models, but can be addressed. I think the debate's particularly relevant to obviously constitutional change advocates as we enter what I think is a new phase in this discussion. What is going to make it into that programme in the short, medium, and long term? Keeping in mind, of course, that there will continue to be good relationships, both institutionally and otherwise, across these islands going forward, and taking into account also the evolving intercultural and diverse nature of Ireland as it is now and as it will develop. To what extent will reunification of this island completely displace many existing demarcations? What will unionism or nationalism mean in a united Ireland, for example? So in those rambling thoughts, I'm going to try in 7 minutes to just raise some questions by way of conclusion to have a conversation. My sense is that the history of the application of the concept will have an impact on the debate. I don't think it'll be definitive, but I think it will have an impact in terms of how people perceive it to have been applied in the past and in the here and now. It's all wrapped up in terms of the future prospects and what the offer will be, what will be on the table, including in particular the implications for the Ulster British tradition here and what the obligations are, how those obligations will be discharged within a devolved arrangement or an integrative model, a blend of the universal and the particular. And as an example, I think, which still is useful, I do think on the Human Rights Commission, a lot of people in this room were involved in the Bill of Rights process. I actually think the Bill of Rights advice that the Commission produced in 2008 is not a bad example of an attempt to combine in one document recognition for some of the principles we're talking about today, i.e. two main communities, with a more universalistic framework going forward. You know, obviously it's a Bill of Rights advice, but I think a solid attempt was made there to think through some of these issues. Are we really talking about also, question mark, that consociationalism will have done its work? And are we really talking in a United Ireland context of preparing for the end of consociationalism over time and moving away from many aspects of the current system? I think that there are proposals on the table at the moment that, and are arguments that show the wisdom in providing an offer that maximizes the potential for a successful United Ireland polity to emerge, and the evidence emerging from polling, surveys, deliberative forums as to what that might look like to try and minimize the loser's consent stuff, right? But how do you minimize the potential for not just opposition, but potentially violent opposition to the outcome? I realize that this all raises a multiplicity of other definitional questions that I'll leave Chris to answer at some point. So I'm only raising more questions. It also makes this conference really, really useful. You know, it's on the anniversary of the agreement. My own sense, and you can tell me that I'm delusional, right? And get in the queue to do that, right? But I do think that we are in a space where the constitutional conversation has a traction that's sort of, the outcome isn't unstoppable, but the conversation is. My own sense is that we are heading towards the choice envisaged in the Good Friday Agreement at some point. So therefore, this discussion is absolutely essential that it continues, because it's going to have to be spelled out in detail as to what that rigorous impartiality obligation actually requires. And you'll know already from the academic literature, there's views within academia about what exactly that might require. In terms of United Ireland advocates, it's probably worth noting today, given what's been said here, there is a rather deep level of skepticism among many United Ireland advocates about importing or hardwiring some of the current mechanisms into the future. So arguments around Northern Ireland being permanent and forever, or aspects of the arrangements here being permanent and forever, would be an open question, I think, in some of that discussion, where people would see a movement away from that. So I think we're entering a phase where something like a prospectus or a programme for a new Ireland, or a multiplicity of those, are going to emerge. When you look at the scale of mobilisation, civil society work, academic research, the work that political parties are doing, the fact that that is happening more so perhaps on one side than the other at the moment, but that's changing. It looks to me like people in this society know that we are heading towards the choice envisaged. So we need to continue these sorts of conversations. The comparative research that's been done and needs to be done needs to be mapped onto credible, deliverable, and ambitious proposals. We need to think through what are, like other people in this room, I often talk about the Good Friday Agreement, values, principles, and obligations, but the obvious response to that, well, what are they? So what are these values, principles, and obligations that we wax lyrical about, and how are they going to be respected in the future, combined with all the other obligations that are there? Final few points in last minute. It seems to me that also the process or processes for getting the answers really matters. It can't be done by academics locking themselves in a room at Queen's and writing this all up, and then, but it needs, process matters. So the process of getting to the answers really matters. That's why it's good to see deliberative forums, citizens' assemblies, people's assemblies, New Ireland Forum, All Ireland Civic Dialogue, all being mentioned and referenced as a way forward to involve people, to engage people, women's assemblies, participation, to hear what people would like to see. Absolutely essential in that, transformative changes in the title, that that transformers are on the pitch. You can be sure that Continuity Ireland are already on the pitch. Transformers need to be on the pitch in that conversation. I think people need to be there for that. Final point then, last 4 seconds. My guess is that the advanced proposals that are likely to emerge are going to contain a blend of substantive proposals around what's going to be envisaged, plus recommendations on process. The initial stage of the process may well privilege continuity, but set down a series of bases to permit transformative options to emerge. But even then, we still have to speak credibly about what the obligations require. So thank you for listening. Look forward to discussing. Thank you.
Very big thank you to this panel. And I'm also going to first ask something to both of you, as has become the tradition of the day now in the panels, which is, I see your papers as really complementary, because I think, Nikos, yours talks really about the mechanisms of the different constitutional arrangements in a comparative way. And Colin's paper asks us about details and thinking about the details of how this would actually work out, which is, I think, really nice complementary way of thinking about the topic. But I'm going to push you both to address some things that have been coming up in this room repeatedly, I think because we are the final panel of the conference, and one of which is, who is Parity of Esteem actually targeted at? Is it for because we had at one time a comment that it's about the governments in the room, or is it the constitutional guarantee to the people, for example, when they want to secede, or constituent parts of a divided society? So we've talked in different times about conflict societies, divided spaces, and maybe different ways of thinking than even communities. But we've looked at in Jane's paper, male, female, or other ways of thinking about parity of esteem, health and physical, mental, all of that. So I would like some of that on who it's targeted at from both of you. And the second is, do you see it as being broader than, can it be drawn out from the conflict background? Because both of you have looked at it from the conflict background. Or should we be limiting it strictly to the divided spaces, conflict, post-conflict kind of situations? Yes, so whoever wants to go first.
Gone for the green mic there, the giveaway there, totally. So
it's my flag.
Yeah, no.
It's blue is my flag.
So, it's good. Obviously, the debate about the nature of the conflict here is a great question. I suppose that just maybe personal. Initially, I would be very much in the school of thought. Certainly, initially, where I thought this isn't a problematic concept, because the nature of the conflict here is an ethno-national conflict, primarily about sovereignty and territory, and we're a pivot for a British-Irish conflict that was fought out here. So it's a relationships between these islands. So the agreement finds a way of trying to address all those relationships, north-south here, across these islands, and Parity of Esteem is one part. So I suppose I see it in a fairly narrow way that is anchored around the two main communities here and around the nature of the conflict here and how you respect that difference of view, given the fact that it isn't a North or Northern Ireland conflict, it's actually a British-Irish conflict that fought out really between these islands. So, and the reason I say that is because then there are other things out there in the toolbox that do all the other stuff as well. So that's why I quite like the way the Bill of Rights here went about. It was to reckon. So there's all this other stuff in the world of human rights and equality, strong equality guarantee, strong human rights protections, and then there's recognition of what the nature of the conflict here, and that you can do all those things well, and in a progressively credible way, all together, without getting into one against the other. So, and the reason I say that is like, and I'm not like I'm not on Senate. I used to be in Senate, but I do think Queen's is one of those places where there are a lot of socially engaged academics. But one of the great things about this society, it's a bit like the Bill of Rights process and other ones as well. People really, including academics here, really thought hard about how you do this stuff. So I think there are things that would be useful in some of the conversations to come. So I hope that's helpful. Thank you.
Thanks.
I will go for the blue mic because of my passport. So, I mean, I think that the whole question about whether we can broaden the parity of esteem to other divisions is a very valid one, and it's present in pretty much every post-conflict arrangement that provides for this kind of heightened protection or heightened status to ethnic, religious, national groups. We have exactly the same discussion in the Western Balkans, in Cyprus. One of the most common complaints when you speak with academics in Cyprus that are involved in the peacemaking process is that we are tired of this divide between Greeks and Turks. What about women? What about LGBT? What about and I think those are all very valid criticisms, not least because to a certain extent those constructs, precisely because they have this kind of post-conflict aim, they tend to kind of freeze the terms of the conflict. They tend to kind of set them in stone, in perpetuity. However, I would also argue that they are necessary in order to get us out of the stalemate. And I would very much agree with what Colin said, that I think concepts like those, the constituent peoples, the parity of esteem, are mainly targeting or covering the ethno-religious or ethnic divide. But then it is up to the constitution makers to provide for additional bills of rights, arrangements, in order to make sure that all the other divisions in the society are covered and there are avenues in order to have effective protection of rights. It's not always easy, and that will be my last comment on that, and we see that especially in the case law of the European Court of Human Rights and the European Court of Justice in post-conflict societies. I refer to Seidis and Finci, where we saw how the way that the constitution was framed in Bosnia created a huge problem for the electoral rights of people that they couldn't find themselves within the three constituent peoples.
Excellent. So yeah, we have a number of hands going up. I'm actually going to be really liberal and allow everyone a chance to also give your comments without a question if you wish, because we are the last panel. However, bear in mind, it should not be the 5-minute long rambling comment, which I will be squirming in my seat and not knowing how to stop. So please be disciplined about it. Okay, so we are going to start here with Chris.
These will be brief questions. So the first question really is to Colin. There's a funny structure for the referendum, which is that the Good Friday Agreement provides for a referendum on a regular basis. So in other words, as it were, nationalists, if we could put it that way, get multiple chances every 7 years for the referendum. From the unionist perspective, that idea of recurring ability is not provided for. So in other words, once the unionists lose, if they do, then they lose forever. Nationalists get it every 7 years, potentially. So I guess that raises two kinds of questions for me. One is, if we're talking about a united Ireland, would that include a right for secession under United Ireland? Which I think would be, for the current republic, a very difficult pill to swallow. And the second question is, I guess, a more personal one for you, which is, you mentioned the question about losers' consent. What would it take for you to buy into the refusal of the Northern Ireland population for unification? In other words, what is a settlement that would be internal to the United Kingdom look like that you would be content with? Because obviously the dialogue we're talking about here is not just a question, ultimately, of persuading people, the 20%, the famous 20%, to vote for United Ireland, but also there will be an attempt by unionists, quite rightly, to persuade the 20% to stay. So what would a successful loss look like for you? In other words, what's the offer you want unionists to make to you in order to enable you to have losers' consent? The broader question is the second one, which is, I mean, quite rightly you said that these negotiations, if they will turn out to be that, take place within an international order, and the international order sets various standards, various understandings, and so on. And that's just international law and international human rights and all of that. But there is a problem, isn't there? Because all these conversations have taken place on the assumption that that order continues. And we've seen in the Brexit context that the way in which the Good Friday Agreement was operated when everybody was a member of the European Union looks very different from the way that the Good Friday Agreement now operates when one party is not, one country is not in the European Union. So given that everybody now seems to be talking about, including the Prime Minister, talking about the new international order, how stable is that going forward? Because on the basis that it's a new international order and that things will be significantly different, I'm assuming that that goes beyond simply economic. We're talking about the potential collapse of the international rules-based order, which previously had provided essentially the context in which negotiations would take place. That may no longer be the case, and what are the implications of that?
Colin, do you want to take that now, or should we gather a few more?
Should I try to? Okay. I don't know where to start on the. I suppose one temptation in all of this is to sort of, against better judgment, is retreat into a form of legalism on this, right? So, which is to say that those are the rules, right? So, and what I mean by that is that the agreement is the endorsed, accepted framework for the conversation going forward, and that many of there is ambiguity there, but there's more clarity in parts of the agreement than people, and actually the constitutional issue section and all of that, you know, the drafts were provided, a lot of legal clarity around that, and that was on purpose and deliberate. So I would say I accept the framework going forward in terms of how it's done. And I suppose it goes back to the question, parity of esteem here has never really been accepted. And I'll put it like this. So people have a right here to pursue constitutional change. They have a right to argue for a new united Ireland. And I think there's a strong sense that this society has never absorbed the reality is that a constitutional fundamental is choice. We have to live in this society. We're mandated constitutionally to live with instability. So you don't have to have a referendum every 7 years, but it's a minimum period until you get another go. And I suppose the temptation would be to say, those are the rules, and I'd be very loath to unpick the framework, but it's a logical corollary to people getting more used to the idea, which I don't think they are. So when people talk about the principle of consent and it just flows off the tongue, it means we have a choice. And the personal bit is, I'd like to exercise the choice at some point. In terms of the, I'm just going to say no to the right of secession. So no, I think it is. This is the resolution to the issue as set out in the agreement, but it does raise a very interesting question, which I posed in the presentation, is the strategic approach of unionism and loyalism to what happens next, and what unionism and loyalism will politically argue for. Because one of the things about legalism is often follows from political struggle, right? So so we have the framework that we have now. What sort of framework will unionism and loyalism argue for in the what-if scenario if it happens is an interesting question. So will unionism, for example, political parties, will they argue for this to be hardwired into the new arrangement? But as you rightly point out, people are going to be very, very loath to open up that prospect, mainly because the agreement framework and what's there already does include very, very strong institutional connections across these islands going forward. And there are multiplicity of other ways that those could continue. What could persuade me to stay in the UK as a current? I'm not going to answer that, but we are already living the dream. We're already living the dream, Chris. But I know it. Yeah, let me be clear. I've heard this. I'm a sort of eat grass United Irelander at this point. Like I'm personally persuaded of this as a constitutional way forward for this island and as a sort of historic resolution of the wider sort of British-Irish conflict. So good luck to those trying to persuade me otherwise. But, however, I do think your question raises a really, really fundamental question, because the weight of emphasis tends to be on the constitutional change advocates, right? So it's on people like me, come up, what's your argument for constitutional change? But I think there needs to be more of a focus on unionism, because it's a great question, right? So if there's a referendum and United Irelanders lose and the UK continues in the current form, what's the offer? So is a unionist offer to people, you're living the dream now, this will continue? Or is it something more imaginative? So you would hope certainly that thinking about parity of esteem, if Northern Ireland continues within the UK, some of those core concepts within the agreement would be actually hardwired in and respected in the longer term. So if people don't like the outcome, at least they can go along with living in that context. And my sense is that hasn't really. You could see from things like the protests outside yesterday, that remains an issue. I don't know how to talk about the collapse of the international order, other than to say it struck me this week. There was an article in The Economist about the connection between NATO membership and the United Ireland. And I find that an intriguing article to be out there. And I think one of the interesting discussions you pick up going around Europe that was there during the Brexit discussions is around the geopolitics of this island. Because in some of the discussions at the moment, this island is being periodically ripped apart by geopolitical international forces, some of which you're talking about. To me, that just reinforces the argument for doing something different on the island, particularly under a European roof at the moment, given what we have here right now. And I suppose the final point, the international order, like United Ireland, global, you have to be part of the argument for arguing about what we do know to be the case for rules-based multilateral systems of solving some of the global challenges that goes beyond this constitutional debate. But all of this, I think there's an onus on all of us to be part of that conversation. But I would say some of it actually lends support for the geopolitical significance of bringing an end to the border on the island of Ireland in the longer term. I don't know if that answers any questions.
Thank you, Colin. We have a number of hands here, but if there is a question for Nikos, I'm going to give you priority right now so that Colin can get a break. Okay, so Ian has got a question for Nikos.
Thank you. Cheekily, I'm actually going to ask a question to each of them, but I'll ask a question to Nikos first. So Nikos, one of the themes that's running through this whole discussion is how broadly we draw this principle. And I agree there are lots of constitutions that either provide for an explicit right to secession or say nothing about secession. There are lots and lots of constitutions that provide for due discrimination or cultural respect guarantees, and especially constitutions in respect of deeply divided societies. But I'm not sure there are other examples of constitutions that specify an expressive duty for the state in respect of that secession process. And I want to press you on that. So I'm very, very newly aware of the Cypriot constitution. I've just had a look at that. I've had a little look at the Danish constitution. I'm not aware of such guarantees in either of those as far as the sort of 5 minutes of Googling I can do. Can I just press you on that? And if I may ask a question to both speakers, though I think it draws on something Colin's just said. One of the things we've been talking about is this ongoing duty of stewardship for the authority that is sovereign in NI. So whether it's the UK government or the Irish government, they'll be obliged to maintain parity of esteem. My understanding is there's no provision, obviously, for secession in the agreement. That's just not contemplated. Yes, but what about rejoining the United Kingdom? The language that the agreement uses is, we'll bring about a united Ireland. That's the end state. My focus is on treaties like the Sino-British Joint Declaration, where once you transfer sovereignty, China says it's a spent treaty, we're done here. I don't think it's likely, but drawing on what we said yesterday about the way in which the political aspirations of each community are evolving in an East-West way, I can think of all sorts of situations geopolitically that would invite large numbers of people in Northern Ireland to want to rejoin the United Kingdom, regardless of how they feel culturally about their community or their identity. What happens then? I don't think this agreement provides for that, but I just wanted to press you on that question.
Yeah, thank you very much, Johan. Right, so it is true that there is a difference between the examples that I provided and the Northern Ireland arrangement. And perhaps the biggest difference is that the Northern Ireland, unlike those cases which are referred, which are all states, internationally recognized states, the situation in Northern Ireland is that it's a region within state. So this kind of obligation goes to for lack of a better word, to the metropolitan state. So yesterday night, I checked whether there are similar arrangements in the Federation, so one of the two entities in Bosnia, and I haven't found something similar because that would be for me kind of the comparator. And I didn't have the time to check whether there is something in Quebec, because that would be the other place where I could check. So I guess for the chapter, if I'm too right, I will come back to this question. But I think it's an important question. Now, with regard to, if I may say just one word, with regard to the question about rejoining the UK, which both you and to a certain extent Chris also mentioned. This is again a question that I appreciate that, of course, it's very vivid here, but it's not only here, right? So, for example, in 2017, in the independence referendum in Catalonia, the aborted one, there was a similar question about the fictitious state of Tavarnia. Tavarnia is like it's a make-up word of between Tarragona, Barcelona, and I don't remember what else, which is kind of the coastal region of Catalonia where more Spanish-speaking people are, and they voted against, right? Or they didn't vote at all. And the unionists were saying, you know what, okay, if Catalonia has a right to secede, what about Tavarnia? Like, Tavarnia should also become independent. And to a certain extent, this was also part of the debate with regard to Quebec, especially with regard to the English-speaking Quebecois. And I'm not, and I appreciate the paradox and the contradiction in the independence position, that you cannot on the one side claim that, okay, we have the right to secession, but then not to provide it to the other people. In the literature, the most kind of coherent, intellectually coherent answer that I have found is in the book of Timothy Walters, right? That he speaks about cascading referendums and things like that. To an extent that this would be practical. To my mind, I think that if you accept the right to secession for your own people, however you claim it, you have to at least accommodate the idea that this can also backfire against you in the future. So I'm one of those people that I'm in favor of the proceduralization of the right to secession when there is a claim, a valid claim within the state.
Thank you very much. It's a really good question. I suppose starting point is that obviously I'm retreating into the existing framework of it here, unlike me, sort of the framework that's there, right, and what it permits and doesn't permit. And also the suggestion that there are alternative ways to satisfy some of those parity type arguments in the arrangements. For example, the continuation of Northern Ireland as an identity and combined with other linkages across these islands and much closer relationships afterwards. The reason I am so anchoring in the agreement is the risks of unpicking it, but it's a very, very good question. And I suppose it links into the point I made about what are the, obviously political unionism at the moment, completely understandably, is staying out of aspects of the conversation, right? So as an event a couple of weeks ago in the Fountain in Derry, which is a sort of unionist loyalist area, debating the constitutional future, sort of pro-union, pro-United Ireland. It was interesting, unionist parties didn't go along to that, DUP and UUP, so they're staying out of that discussion. But it will be interesting to see what the asks are, particularly if, like, what surprised me is how quickly a lot of people moved to the position of a new constitution for a new Ireland, right? So probably most realistically after a referendum, some kind of process around that. But you're absolutely right, and Chris is well. Unionists at that point or before it will then be engaged in putting a lot of these sorts of ideas on the table in the context that there will be other agreements as well in a British and Irish context. So one of the questions that I asked, says, what is it that unionism and loyalism will want to see in the new arrangements? And, what are they prepared to do in order to get there, right? And I don't mean anything necessarily sinister about that. I just mean the whole process of boycotting, impeding, of just not playing ball at all with the thing. So I'm just saying it's a very, very interesting conversation. I don't think we have any definitive answers on it. I'm certainly not going to give one other than doing my sort of retreat into the agreement framework and seeing that the institutional and other arrangements that puts in place for the present and future go a long way to satisfying many of the ambitions of two main communities, including protections for British. But what do you do at that point or a point in the future if people say, well, actually that's not sufficient, we want something else? in your transformative conversation that you want to have about doing everything differently. So.
Thank you. Okay, so we have now Colin, then Jane, then Leah also. Or Jane, you were not in the queue? Okay, so Colin, Leah, and Simon. So starting with Colin.
Thank you, both speakers. Question for Nikos, question for Colin. Nikos, in your European tour, I was a little bit depressed because you rightly emphasise the importance of the post-conflict dimension, in quoting Christine and others. But many of the countries you mentioned, Cyprus, Bosnia, Macedonia, sorry, Northern Macedonia, have yet to, how would I put it, really emerge from the post-conflict dynamic, with Macedonia perhaps being an exception to that. But Bosnia, Cyprus, perhaps here, very much locked in the post-conflict dynamic. And I'm curious, do you think that parity of esteem can ever really escape from being a post-conflict concept to being a constitutional stabilization concept? I'm curious about your views on that. Colin, bearing in mind that the agreement does say that any future Irish sovereignty over Northern Ireland has to respect the parity of esteem agreement, what sort of minimum level of detail on that do you think political parties in Dublin should be offering to unionists in the North before you can have a serious discussion about unification, reunification referendum? What sort of detail do you think basically unionists are owed in the run-up to a serious conversation about a referendum from Dublin in relation, Dublin broadly defined, in relation to that clause in the agreement about guaranteeing parity of esteem after a sovereign handover?
Shall we gather a couple of questions?
No, we have time.
Okay,
You can
okay.
go.
Yeah, thank you very much, Colm. I mean, it is difficult. It is very, very difficult for the reasons that you explained very eloquently yesterday. That there is kind of a default position towards the Jacobean approach of constitution making, that without some kind of pressing historical, political, circumstances, that the constitution makers would actually adopt in their own volition such an approach. Even in the case of Spain, where we see certain characteristics that happened because it was the democratic transition period, right? So it was the defrancoization of the regime. So can we think of a situation whereby a constitutional order would adopt on its own volition without having this kind of pressing need, such concept? It's very, very difficult to see. Not least because, I guess the path dependence is that the political elites would try to create a constitution that would kind of serve their own needs. And, this is not to create another kind of level of checks and balances, because it's another, when you have this kind of system, you complicate, you overcomplicate. So, yeah, that's it. Do you want the blue? Are you sure? Are you sure?
I've changed my mind now. I've been persuaded by all these excellent questions. So, what do I think? Yeah, I think really interesting sort of pendulum sovereignty model in the agreement that the Irish state will have to discharge these responsibilities, and that's why that blank page stuff is so. What does it mean? So there is parity of esteem, but Colm was saying earlier, all the other human rights language in that provision as well that gets skipped over too, and where it's sat for so long. Like there's a debate about this. So the Richard Humphreys sort of argument, which is essentially accommodation now. So why wait? until you're in this process of reunification. Why not make some of these changes now? If you accept that the current Irish constitution needs to be changed, then get on with it. Do it now to make that clear. And on that argument about, and I know there's even an argument on that about the current constitution, is the current Irish constitution would need to change, to even basic things around voting rights and who can get to vote. I think you can't have a situation where people who identify as British only or British aren't able to. It's just that things like that are. They would, the current system, the constitution needs to change to respect that. I've given a sort of hint at there's things that have been tried in Northern Ireland around how you do this that I think are helpful for that, what that obligation means in terms of what the current constitution should do. But no, I absolutely think that the current arrangements would need to change. I do see the argument around doing something about that in advance of a process of not treating it like a sort of bargaining chip, although there's that school of thought as well. Why would you do that beforehand? So, yeah, I think there are ways to do that. And I think the big conundrum for me is back to the paper I'm sure was discussed yesterday. The agreement discharges a lot of the responsibility of the sovereign government through devolution and through a devolved Northern Ireland. So that raises the question of, actually something I've tried to think about, do these provisions require some of the stuff that we have now legally? Might that be legally fought out as well in terms of the argument that how much of the stuff that's here now in terms of power sharing, consultation, are actually legally compelled via that provision will be an important part of that discussion. But there are clues there. I think the big difficulty will be of whom there are many actually, who feel that the current arrangements are transitional, that and in an ideal situation they will go away over time into a much more integrated, not a centralized United, but a much more integrated all-island framework. And I think for that model, there are particular challenges around the question, I think.
Thank you, Colin. Leah.
We have a question over here as well.
Thank you both. I have one question for both of you and two very quick comments because I was promised I could. So the question is for both of you, this is like a proper curiosity question. When I think about territorial conflicts that need to be decided and then are decided, one of the things that happens when territorial allegiance switches over is that winners become losers and losers become winners in a situation where the respective identity before is a very important part of who everyone thinks they are. Are there processes available, both legally and politically, to navigate that psychological change? Because that seems to me to be really challenging. I certainly wouldn't know how I would react in that situation. So if you have any thoughts on that, I would be so interested in those. The comments are, so on running referendums in general, there's two things the Swiss experience suggests. One is to say that, so the problem, both the strength and the problem of referendums is that it's often only yes or no. But there are systems, including Switzerland, that do no three-way questions. Maybe could be thought about. because of what Colm just said, namely that referendums are mostly ideal as a confirmation, so as a ratification tool, that recommends a lot of detail before anything is decided. But because one question can then become really overburdened with all sorts of things, a disaggregating of votes can be helpful. And I think the Jura solution suggests that that's good. And finally, have really good rules on voter information. In other words, do not ask the UK how to do this.
Can we take Simon's and Jane's also so that we have all of them?
Yeah.
And one that side. Let's just gather them all.
So this is more a question about the upcoming generation, especially in a lot of the literature I look at. They call them the peace babies, the kids born after the Belfast Agreement. With key decision makers, senior political figures being born and witness to some of the worst of the violence during the Troubles, with the upcoming generation entering those same senior decision-making positions, how might we see a shift in both the constitutional and grassroots application of an understanding of parity of esteem? So how would the new generation usher in that? Thank you.
Mine are more comments, Devyani, so maybe they
Okay.
answer questions.
Can we get Jane? Is yours a question or a comment?
I'd like a response, I suppose.
Great. So
to
that's
my
a question.
comment. I feel an obligation now to ask a question because you thought I was in the queue, but also because I presented my paper on feminist constitutionalism and the response to a wider definition of parity of esteem and whether it goes along beyond that ethno-national divide. I think both of you agreed that it doesn't, that parity of esteem really is about that. And in the Irish context, it's about unionists and nationalists. And having lived in Northern Ireland for 20 years, but as a child of the Good Friday Agreement, I think that it would be a mistake to characterise parity of esteem in that very singular way. Because certainly for my generation and the people coming behind me, Gen Z or whatever they call them, they would think of that as a regression in politics. And our perception of that process is male-dominated, middle class, white, and also in some respects parochial, because young people have greater problems. They can't afford housing. They can't afford to move out of their parents' house. We have, there are different, there are asylum seeker populations much greater now than there were in 1998. So if parity of esteem is framed along those ethno-national lines moving forward for a future constitutionalism, I think by framing it in that way, you're automatically excluding people who might see the benefits of a united Ireland, especially in the geopolitical global context that we're in, regardless of the 10% tariff that the UK is privileged to under the US new tariff regime. I think that would be a mistake, and there is wonderful work being done by the Feminist Constitutional Futures Group, which isn't just about women, but talking about and defining peoples and constituent powers along much more contemporary lines. So that's all I really wanted to say. And I hope that there's a response to that in some way.
So shall we say 2 minutes each for responses, and then we have a minute for Simon's comment in the end?
You want to start? Let me start with your question. about the new generation. And I mean, I will just say that I'm not going to speak about Northern Ireland because I'm not from here and I don't know the new generation here. But in other places, when we had a shift in the population and we have moved towards generations that they haven't experienced the trouble, the equivalent of the troubles, the new generations have become more reluctant to reconciliation. This is the case of Cyprus, right? So we see in the newer generations, both sides of the divide, that they are way more nationalists than people that have lived with the other side. I hope that the situation here is different. I guess it very much depends on the society. A very quick answer to Jane. I completely share why the reading that I suggest is problematic. I completely get it. I think that it is problematic, and as I said, in pretty much all the conflicts, all the constitutional arrangements where there is this concept of constituent peoples, or we have this kind of criticisms, and they are very valid criticisms. At the moment, I think, though, that the Parity of Esteem is translated in that way. Whether it should, normatively, probably not. But at the moment, I think this is the prevalent interpretation. And finally, thoughts on how to deal with basically losing the argument. I think this is one of the most underappreciated aspects of a referendum campaign. How you prepare yourself to lose. There are other cases, there are very few cases where people have actually made some effort, because nobody goes there to lose, everybody goes there to win the referendum. I remember I was in Scotland back in 2013, and there were some secret they brought some people from Quebec, because at the moment there was no possibility of winning the referendum, right? So there were some secret meetings of how we are going to prepare the Scottish independence for an eventual defeat. But that remained, to my understanding, secret meetings. I don't think that this has spilled over to the society, but I might be wrong. So I think that there is a lot of scope when it comes to referendum campaigns about actually providing an environment where either of the two positions wins. And yeah, I completely agree with you that sometimes the binary character of the referendums create a problem. Perhaps we have to look at this kind of multi-choice things. Anecdotal completely, in 2015, when we had the Grexit referendum in Greece, I proposed something like that, and I remember a comment that I got in Twitter. So, what are you gonna vote? Maybe on Sunday, because there was, of course, a yes or no, and I was like, yeah, you have a point there, dude. I mean, I can see why you are taking the piss out of me, but I can see the value of that.
Okay, just try to address all the questions. I suppose starting point around the political science concept of loser's consent, which I think is rather unfortunate concept, but it's there to do useful work, I think, in terms of how we deal with what happens afterwards. I suppose starting point is that often don't get very far in these conversations without people raising the question about violence. So there's been conflict here, and there's a concern about what happens next. I've often been struck in various dialogues with even people who would label themselves as moderate unionists, who quite quickly begin talking about just hypothetically, bombs going off in Dublin and things like that, you know. So I just want to put that on the table as, so why it matters? Well, it matters because then we need to find ways, if political unionism won't engage in advance of a referendum, there's an onus on those who want this to work and get this right and be responsible to work out what will make people feel maximum comfort, safety and security in what happens next. So, so there's the legal stuff, right? And my epic retreat to black letter law today and legalism around the agreement, and 50% plus one and all that, and that's all. But ultimately, I live here, you're here, human rights care about what happens next, want to get it right. And that really has struck me about a lot of the work in this area is there's a real sense of owner's responsibility to get it right. And why am I saying all that? Well, the Aaron's work, the Irish Times, you know, and even that, like a major newspaper on this island is devoting considerable resources and time to working this stuff out, is unearthing a lot of really useful evidence about what might make people comfortable if this were to happen. You might not want it to happen, but what might make comfortable. I think more of that work needs to be done. There are various dialogues. You know, I keep hearing about how polarizing this debate is, and every other day of the week I'm in a conversation with somebody from a civic unionist or loyalist background talking about the constitutional future of listening. And some of that will be probably uncomfortable for people who are involved in a constitutional change conversation. But if this is to got right, then there's wisdom, I think, in like Chris asked me at the break, what do you mean by generosity? But of generosity in approach to what the offer is. In terms of other new generations, like when you were in here yesterday, I suppose one thing I would say is there was a protest happening outside the gate. Have a look at the age demographic of the people outside the gate yesterday. That was and what's often struck me about civic activism across a range of areas in this society is just how much young people are already civically active in achieving all sorts of change in a whole range of rights-based and equality-based areas. If you're a peace baby, I'm a conflict baby. I was born in 1970, so the whole thing was my normal, you know, growing up in Derry. So I'm one of these people who think what has happened here is sort of a bit miraculous. It's a relatively successful peace process. There are big problems and challenges, but, you know, this place has come a really long way. And what is really noticeable in the proposals that I mentioned already is around participation and engagement, and that includes children and young people. There are excellent people who work at Queen's, for example, Laura Lundy, who works in this university, who's worked out models of how you engage with children and young people to ensure there's effective participation. We need to, like, I'm serious about this. The process really matters. It can't just be people sitting in universities deciding the future and just presenting it as a fait accompli. It needs to be a participative process. And the final question about feminist, look, don't get me wrong. The conference is called Parity of Esteem. I'm just sort of fulfilling my remit from the event. There's an obligation in the agreement. It's there, so we need to work out what work it does, right? So, but it isn't everything. It's just one principle among many principles and rules. And so given that it's there and given that it'll frame the future, we just need to have a really in-depth conversation like this about what it will require. The past suggests that that was never really resolved. Do we need to resolve that for the future? And what's really striking about the rigorous impartiality clause of the agreement, a bit like the Bill of Rights proposals, are the wraparounds. So Parity of Esteem in the part of the agreement is wrapped around with other things as well. So it absolutely. And I would be very much, you know, there with a lot of the transformative arguments about the opportunities that it presents doing something differently. But Parity of Esteem is a concept that's there. It will apply to this conversation to come. So just work out what work it is to use. My inkling would be not to load stuff onto it that it can't bear, because other concepts do that work, and there are other things that do that work as well, particularly in the equality and rights field. So hopefully that's helpful. Thank you.
Thank you, Colin. So we do not have a tea break. So we are morphing into the final session, just like the documents we save as final doc and final doc. So we'll get Simon's comment first, and then we will roll over into the next session.
Thank you. Thank you, Devyani, and thank you, Tom. And thank you to the speakers. When I was Dean of the law school here over 30 years ago, I remember one reference for a student. The headmistress said, let's call her Mary. Mary has got top grades all the way through school. She works hard. She perhaps lacks imagination. She would make a great lawyer. How is that meant to persuade us? And I think what I wanted to say is the gift, if you like, needs to be worked out. The skill of imagination is very important in all of this, whichever direction we're talking about. So in the past, I imagined what the Adams-Hume document would look like, wrote in the Irish Times. Then I imagined what a unionist response would look like to the Republican ceasefire and wrote that in the Belfast Telegraph, and so on and so forth. But I think that is very important now in universities, because when I was a student with Chris, only 5% of the country went to university, but now 50% do. And how universities model behavior in terms of the environment, sustainability, or in this case, dealing with things. Or to take the area of parity of esteem, mental health with physical health, how universities react to suicides amongst their students and staff. These things have changed quite dramatically, mostly for the better, still a long way to go. And universities themselves have got experience of secession. So Colin's just staged a walkout, but we've got people here from Newcastle and Durham. Newcastle University seceded from Durham in 1964, at the same time as Essex started from zero. Imperial College seceded from the University of London, and so on and so forth. And in each of those institutions, there would be people who didn't want to go, who lost the vote, who actually valued the federation. And sometimes you're in a position where your identity, for instance, if you're English, your identity might be changed by referendums in Scotland, in Northern Ireland, in Wales, all over the place, the European Union referendum, and you don't get a vote in all of them. But universities can model behavior as to how to live with trying to develop this imaginative concept of parity of esteem. Thank you.
Thank you, Simon. And with that, I thank the panel.